So now that we have an overview of the federal court system and we know how a case can work its way through the system, let's talk about the doctrine of stare decisis. Stare decisis. Stare decisis is a policy that courts have of following the rules and principles that are set out in previous judicial decisions. What we're talking about here is the concept of precedent. Precedent. When a rule of law is established for the first time in a particular type of case, so let's say this rule comes from a case, okay, then courts that decide similar cases later on in the same jurisdiction, they will follow the rule set out in the first case. Right? The reason we have this doctrine of stare decisis is that we want to ensure some certainty and consistency in how the law is administered. If someone is convicted in the first case of murder for shooting and killing a person that he thought was a burglar, well, then it's only fair that if later on someone in the second case also shoots and kills a person that he thought was a burglar, that he too would be convicted of murder. This also lets lawyers have a pretty good idea of how a case is going to turn out without actually going through the time and expense of trial. Okay, so the lawyers will know that the court is going to follow the rules set forth in the first case, so they can settle the cases instead of clogging the court system with a bunch of similar cases. So let's see how this works. Let's say that a person sees what he thinks is a wild dog on his property. Right? And he shoots and kills it. But it turns out that the wild dog was actually a rare and endangered species of wolf. Okay? And that species of wolf is protected by the Endangered Species Act. You're not allowed to kill it. Okay? The Endangered Species Act is federal law, so the U.S. attorney is prosecuting this man in federal court. And let's say the man lives in upstate New York, so we're in the Western District of New York. Right? We're in the district court for the Western District of New York. Now, let's assume that something like this has actually never happened before. People have legally shot wild dogs before. And people have illegally shot endangered animals before. But there hasn't been a case of someone shooting an endangered animal that he thought was a different non-protected animal. He thought it was a dog. Right? And if the Endangered Species Act doesn't say anything about whether you have to know that you're actually killing an endangered species, well, then it's up to the court to decide whether that matters. So let's say that the district court for the Western District of New York decides that the man is not guilty of violating the Endangered Species Act. Not guilty. And the court decides this because it rules that you can only be guilty if you know that you're harming an endangered species. And that's how the court has interpreted the Endangered Species Act. By doing so, the district court for the Western District of New York has set a precedent for that district. So now let's say that the U.S. attorney appeals the decision to the circuit court. And because the Western District of New York is in the Second Circuit, the appeal goes to the Second Circuit Court of Appeals. And let's assume that the Second Circuit Court of Appeals reviews and affirms the lower decision. It affirms the decision of the District Court for the Western District of New York. Okay, now the Second Circuit Court of Appeals has established a precedent for the entire circuit. So if later on someone in the hills of Vermont shoots and kills an endangered bald eagle, but he shoots that eagle thinking that it's a crow. Right? It's a very similar situation. If that happens, the lawyers will probably have a pretty good sense of how that case is going to turn out. In fact, if the defendant really thought that the bald eagle was a crow, he'll probably be found not guilty. Not guilty of violating the Endangered Species Act. And that's because the District of Vermont is inside the Second Circuit. And so it's bound by the precedent, by the prior decisions of the Second Circuit. So if the case were to go to court, if it were to go to the district court for the District of Vermont, that court would recognize that the same issue had come up before in the Western District of New York, and that the Second Circuit had affirmed the Western District of New York's not guilty decision. So the district court for the District of Vermont would be required to follow the binding authority of the Second Circuit. And so it would also find this defendant to be not guilty. Okay, now let's look at another incident, but this time it's in the Ninth Circuit. So let's say that after all of this, someone in Northern California shoots a northern spotted owl. Right? But he shoots the owl thinking that it's a pigeon, a non-protected bird. All right, the lawyers know about the cases in the Western District of New York and in the District of Vermont, and they know about the precedents set by the Second Circuit Court of Appeals. But remember, the Northern District of California is not in the Second Circuit. Right? So it's not bound by the Second Circuit's decisions. Decisions from other circuits are not binding authority. They are only what we call persuasive authority. They may help guide the district court for the Northern District of California, or they may show an example of how this issue could or should be resolved. But the Northern District of California needs to follow orders from the Ninth Circuit. And because the Ninth Circuit has yet to rule on the issue, the Northern District of California can make its own decision about this. And let's say that the Northern District of California District Court decides that, well, sorry, just because you thought that the endangered owl was actually a pigeon, that doesn't get you off the hook. You are responsible for knowing what you're shooting, and if you shoot an endangered species, you have violated the Endangered Species Act, period. Guilty. Well, now the defendant in California is upset. You know, hey, the trigger-happy guys in the Second Circuit out east, they're being let off the hook. Why should I be fined or maybe even imprisoned for making the same honest mistake? So it's likely that the defendant will appeal the decision of the Northern District of California up to the Ninth Circuit Court of Appeals. And here again, the Ninth Circuit is not bound by the decisions of other circuits. The Second Circuit's prior decision is persuasive authority, but the Ninth Circuit can choose to follow the Second Circuit's precedent, or it can go its own way. And let's say that the Ninth Circuit, in fact, decides to go its own way, and it affirms the decision of the Northern District of California. It affirms the lower court's decision. So it's going its own way. It's not following the precedent of the Second Circuit. Okay, so let's review. If you accidentally kill an endangered animal, thinking that it's a non-protected species, you will have violated the Endangered Species Act if you're in the Ninth Circuit. But you will be let off the hook if you're in the Second Circuit. So the lawyers in those two circuits, they all have a pretty good sense of how things will play out if a similar incident occurs within one of those two circuits. All right, now let's say we're in the District of Columbia, and a man there shoots and kills an endangered animal. I'm not sure what kind of endangered species there are in DC. I don't know. Let's say there's a lone grizzly bear. There's a lone grizzly bear that hangs out near Georgetown somewhere. Okay, so that the man killed this endangered grizzly bear, thinking it was a stray cat, a really big stray cat. So he thinks it's a stray cat, It's actually an endangered bear. And now the question is, has this man violated the Endangered Species Act? Now, this has never come up before in the DC Circuit. There's no binding authority on this issue in this circuit. So if the case is brought in the district court for the District of Columbia, the court can make its own decision. It can follow the persuasive authority of the Second Circuit, or it can follow the persuasive authority of the Ninth Circuit, or you can even come up with a third way of ruling on this issue, maybe some other sort of test for determining whether the defendant has violated the Endangered Species Act. But let's say that the district court for the District of Columbia follows the persuasive precedent of the Ninth Circuit and finds that the grizzly bear killer is guilty. Well, if that's the case, you can be sure that the defendant will appeal that decision to the DC Circuit Court, right? And then he'll argue that the DC Circuit should follow the Second Circuit's example and rule that he's not guilty. And let's say that that's exactly what the DC Circuit Court does. It reverses the lower court's decision and rules that the grizzly bear killer is not guilty, right? For the same reasons that the Second Circuit had for finding the wolf killer to be not guilty. So the defendant is happy. He's off the hook now. But not so fast. The U.S. attorney may file a petition from the DC Circuit Court, may file a petition for certiorari to the Supreme Court and argue that the Ninth Circuit's approach is actually the better rule. And this is a situation where the Supreme Court very well may grant cert. The Supreme Court will look at this and notice that there is a circuit split. A circuit split. Okay? Different circuits, different jurisdictions are tackling the same issue in different ways. We've got people out on the West Coast in the Ninth Circuit who are getting thrown in jail because of mistaken bird identity, right? Because they killed an owl thinking it was a pigeon. Meanwhile, people out in the Second Circuit out east are being let off the hook for killing endangered animals because they thought that a wolf was a squirrel or something, right? And now the DC Circuit is about to follow suit for a guy who thought that a grizzly bear was a cat. And so none of this seems very consistent. And it creates some uncertainty too. What about people in the middle of the country, in the Eighth Circuit or the Sixth Circuit? What should those people expect if a similar situation arises there? So let's say that the Supreme Court grants cert. It grants cert to the U.S. Attorney's appeal from the DC Circuit Court, and it accepts the U.S. Attorney's argument that the Ninth Circuit has the better approach. So the Supreme Court reverses the DC Circuit Court's decision. So the grizzly bear defendant is now back to guilty. And more importantly for the legal system, the entire country is now bound by the Supreme Court's ruling. So from now on, it doesn't matter whether you thought the endangered animal was some other non-protected species or not. If you kill an endangered species, an endangered animal, you have violated the Endangered Species Act. Going forward, all courts in the country, even those in the Second Circuit, are now required to follow the binding authority of the Supreme Court on this issue.